Let's go straight to our top story tonight, and this is about the three new criminal laws. The Indian Penal Code, Code of Criminal Procedure and the Indian Evidence Act are all laws of the past, as the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam come to replace them. The three new criminal laws have come into force, replacing the centuries-old colonial era laws. In fact, Union Home Minister Amit Shah attempted to allay apprehensions as well of the opposition and reiterated how these new swadeshi laws will guarantee speedy trials and focus on justice instead of punishment. But despite government's attempts, opposition's stiff objections against these new laws continue. Congress MPs Manish Tiwari has demanded an immediate stop on the implementation of these three new criminal laws. He's also suggested that the parliament should re-examine them. In fact, opposition leaders have also claimed that these laws were pushed through parliament without adequate discussion, deliberation or debate, and that the changes that these laws bring in are merely cosmetic. So the big question is the overhaul of India's colonial criminal laws an actual overhaul or an overreach? Let's listen into some political reactions before we take this question up with our panelists tonight.
When I had done the research, I had found that this is nothing but the manifestation of vanity to leave your imprint. This is an opportunity to create genuine reform. Unfortunately, what has happened is cosmetic changes, 90% remaining the same, numbers changed, a few words changed here and there, and then re-inaugurated as the new central vista, the new set of laws by this government. That is most objectionable.
ये संहिता के लिए कुछ विपक्ष के मित्र अलग अलग बातें मीडिया के सामने रख रहे हैं कि अभी ट्रेनिंग नहीं हुई है, चर्चा नहीं हुई है। मैं आप सभी को बताना चाहता हूं कि लोकसभा में कुल मिलाकर 9 घंटा और 29 मिनट चर्चा हुई है। 34 सदस्यों ने इसके अंदर पार्टिसिपेट किया है। राज्यसभा में 6 घंटा और 70 मिनट चर्चा हुई है। 40 सदस्यों ने पार्टिसिपेट किया है। एक ये भी झूठ चलाया जा रहा है कि सबको बाल निकालने के बाद ये बिल लाया गया। बिल बिजनेस एडवाइजरी कमेटी में पहले से निश्चित था। मेरा ये स्पष्ट मानना है कि 14 तारीख से ही विपक्ष ने सदन का बहिष्कार करने जैसी हरकतें करी थी और शायद वो हिस्सा लेना नहीं चाहते थे।
All right, we're now joined by Desh Ratan Nigam, who's a senior lawyer, to discuss this further. We'll also be shortly joined in by another guest. But let's first take this first question to you, Mr. Nigam. I really want to understand the basics first. How are these laws, how are these three laws that have been replaced with the older set of laws, how are these laws going to bring in reform as far as India's criminal justice ecosystem is concerned, criminal justice system is concerned? Why were these needed and how will they help in bringing reform? If you could just explain that for our viewers.
I think it was long overdue, and since we had these laws in the 19th century, and there was a time to bring it in tune with the modern India. And therefore, a lot of technology has been used. The zero FIR can be done because, a lot of dispute arises as to whose jurisdiction this case will file. And therefore, they were not even registering the FIRs. And therefore, it can be registered in any police station, and then it can be transferred the court of to the police thana of appropriate jurisdiction. The summons can be sent by through digital means like SMS, emails, and otherwise also to enhance communication. This all will, reduce a lot of time, speedy trial, and fixing the time period, for passing a judgment after hearing is concluded. 45 days that has been done, and charge sheets need to be filed within 60 to 90 days. Otherwise, a person gets default bail. So these are the issues which are there, and enhancing. These are procedural aspects. But if you look at the substantive law, which is Bharatiya Nyaya Sanhita, in short BNS, there a lot of crimes have been introduced, like terrorism, which is there, and it is also there in UAPA, but the discretion has been given as to under which law it can be done, because UAPA is a far stringent law where you are guilty till proven innocent. But under the BNS, you are not guilty till proven innocent. You are innocent till proven guilty. So those are the differences which are there. Organized crime has been brought in, economic security, anybody who threatens economic security. This is a substantive change, and the sedition law as it existed has been done away with, which was one of the most misused section by the police or the various previous governments, because it's not the government which registers against the police. So anybody who said anything against the government was put under sedition. But here they have removed the word government and brought in the anybody by their own acts which threatens this unity and integrity of India. So that's a welcome change, a huge change which has come, and something very important for minor offenses. They have, introduced community
as far
service.
as these laws and how they really will lead to an overhaul of the entire criminal justice system is concerned. You've also brought in a very important point as far as jurisdiction is concerned, ongoing digital is concerned, on, of course, sedition. We'll touch upon all of those points in just a bit, but let me also take first comments from Mr. Sanjay Hegde, who's a senior advocate of the Supreme Court, who's also joining us. Mr. Hegde, the opposition members of civil society, and of course the legal fraternity, including the Delhi Bar Council, which is now written to Home Ministry, has been stating that these laws, some of the provisions will compromise civil liberties. They could lead to state outreach and expanded police powers. What are the implications that you really feel as far as some of the provisions of these laws are concerned with respect to what Mr. Desh Ratan Nigam has spoken about?
Well, it is said that the history of human liberty is the history of insistence on fair procedure. These laws, as they currently have been brought into existence, change that balance. They are not pro-citizen, they are pro-executive, they are pro-police. The police can, for instance, they need not take your custody only for 15 days. They can keep you in custody for up to 90 days. 90 days of police custody, enjoying the hospitality of the police in all its magnificent glory, means that a person would possibly confess to almost anything. The point is that these 90 days are not consecutive either. The police can take your custody for about 5 days, return you to judicial custody, then again take you after some time for 10 more days, and so on and so forth, until the police say that, okay, we are done with police custody, we don't need police custody anymore. Courts are very unlikely to get bail in the system that hitherto existed. With 15 days of police custody, most cases did get solved. What was the need to increase the period to 90 days? Then the police also have a discretion in registering of FIRs. They can do a preliminary inquiry, and we know what a preliminary inquiry means. It would possibly turn the police stations into mini courts, and courts not necessarily in a good sense. People would have to quote the policeman to either register a complaint or to see that a complaint is not registered. I think the delicate balance between human liberty and state power has been grossly tilted now towards the state.
Right.
Yes.
Right, Mr. Hegde, very valid point made. Mr. Nigam, it seems the custody for 90 days that point is very important given the atrocities, police atrocities we have seen in the past, and some under trial cases have still been pending. How do you really respond to what Mr. Hegde has said?
Well, let me make it very clear. Even in the previous one, Indian Penal Code or Criminal Procedure Code, there was a time period for filing a charge sheet. Until then, unless until the court wants, the bail was not given, then there was a concept of a default bail if the charge sheet was not filed. as it happens in customs and other cases also. So here what they have done, that they have, fine-tuned or harmonized those aspects and said 90 days custody. But here the courts will grant. It is not the discretion of the police. They will have to request the court, and therefore courts are the final arbiter of this issue. And people were not getting bail in the earlier ones. Now what they have done is they have fixed 60 to 90 days time period for filing charge sheets, and till then the courts have the right to grant bail. So I don't think there is any problem out there, and any absoluteness on the part of police. There is a court as a check and balance, and we can always, and as the Bharatiya Nyaya Sanhita and the Suraksha Sanhita go to the courts, and courts will make their own interpretations. So we'll have to see how it works. So we cannot jump the gun. And secondly, the objective of the act is justice, not the penal action. So they have tried to balance the right of victims and those of accused. Now, if accused is unnecessarily harassed, then there are courts to look into, as they look now. So the courts have very wide powers. So unless and until, you balance the victims with the accused, earlier the victims were not balanced. Here, a lot of new crimes, minor rapes, death penalty, and so many things have been brought in. And women sensitive, changes have been made. And the chapter on women is earlier than many other, chapters. So the focus of the government is very clear. Yes, there are chances.
Mr.
One last
Nigam,
thing.
Mr. Nigam, I'll come back to you. I'll come back to you in a bit. I'll come back to you in a bit, but I think a very important point was mentioned with respect to sedition. You said that sedition has been done away with, but Mr. Hegde, then it really reappears with additional references to sovereignty and integrity of India. Do you really think that these new references make the new law more draconian with respect to individual freedoms, and how it really plays out with respect to protests and gatherings, and how there could also be a case for misinterpretation?
Is vague, overbroad, and it also includes references to economic sovereignty. Now, you must remember the big story that your channels did on the Hindenburg report. Now, there was also a defense of the Indian corporate by saying that this is an attack on India's economic sovereignty. There are 800 police districts in India. Do you think that all the policemen in charge of those various districts will be equally solicitous about the freedom of speech or about journalists doing their jobs? Somebody can very well call some senior cop in charge of Jamtara or Jumritalaya and say, look, this particular report impinges on India's economic sovereignty. Register under the new Nyaya Samhita, and we will see how the journalists based in Bombay can carry on this kind of attack on India's economic sovereignty. So the point is that there has not been a clause-by-clause examination of this by judicial minds or trained minds outside the system. It was a committee which came out with the first draft, then it went to introduced hurriedly in Parliament, went to a parliamentary standing committee where people like Mr. Chidambaram recorded their dissents, and then it was passed through a parliament where there was no discussion possible, where a large number of opposition MPs had been suspended, and it was notified ahead of the elections. So and today it's come into force. The problems which these laws have brought in will work their way through the system over a substantial period of time. It is not as if like in demonetization, things settle down after about 6 months or so, or with the introduction of GST, those problems are still working their way through the system. Problems created by this kind of wholesale broadening and over-broadening of the law
to Mr. Nigam, you raise a very valid point. Right.
It will work their way through the system.
You raise a very valid point as far as the Right. You raise a very valid point as far as the implementation of these laws is concerned, that the fact that, you and some other members of the legal fraternity have stated that there was not enough deliberation, there was not enough debate and discussion as far as these laws are concerned. In fact, Mr. Amit Shah, Union Home Minister, was stating that 158 meetings happened, 93 changes were done, deliberations went for 4 hours in one of the houses, and that, it's an India-centric law, and 9 hours of discussion and debate really happened in Lok Sabha. He also stated that the opposition should not politicize the issue. Do you really agree with that? Is it not politicizing the issue, especially with respect to the stats that he's mentioned today in a press conference?
Am I to respond, or are you asking Mr. Nigam?
Mr. Hegde.
Okay.
Yes, Mr. Hegde, this is to you.
See, all those meetings, they were within the committee itself, the committee appointed by the government. The committee invited suggestions. What it did with the suggestions, nobody knows. Then, most of the discussion in Parliament was just the government introducing the bill. Very often in important bills, there is a clause-by-clause reading. Here, a truncated Parliament cannot necessarily rely only on one side. The ruling party, you are not going to have any MP stand up and say, I think this bill is wrong, because all of them are bound by the party whip, and they are bound to vote for that particular legislation. So you will never see dissent, you will never see examination on the ruling party side. So yes, they 4 hours in one house, 9 hours in another house. Was it adequate for laws which run into hundreds of sections, both the procedure code as well as the penal code? I don't think there was sufficient discussion.
Absolutely, Mr. Hegde. Absolutely, Mr. Hegde. So there wasn't enough and sufficient time given to deliberation and discussion of these laws in the Parliament, is the point that Mr. Hegde is making, Mr. Nigam. How do you really react to that? And most importantly, how can a truncated Parliament pass laws when over 140 of its opposition MPs were disqualified and their comments were not really considered? How do you really respond to that?
Two issues, Sumita, out here. One, the decorum of the Parliament. If you do not adhere to it, the speaker will take action, or the chairman, as in the case of a Rajya Sabha, will take action. And if you do all that, what has happened, and we are seeing the quality
presence of over 140 MPs?
Yes, no, because it was a wholesale mass kind of disruptions which were happening, and it did. And certainly this should not happen, but then the opposition has a role to play. If you abandon your role, then what can anybody do? Amit Shah made it very clear today that they had already made their mind to boycott it, and then the kind of halla-balla and lack of decorum taking place. And I think our Parliament needs to come back to its own discussions and debates. And ultimately, when such kind of laws are passed, and some of them, these sections, yes, there are apprehensions, no doubt about it, but there are courts to look into it, as was in the previous, IPC or CRPC. And the courts will always be there. In criminal law, there are excesses by police. Nobody can deny that. As a lawyer, even Mr. Hegde knows about it, and we go to the court for redressal of our grievances. And however, so far as implementation is concerned, large effort has gone, but it will take time to seep at the lowest level of the police hierarchy. And a lot of training sessions have to be done, and over the period of time, and it will stabilize. And any big change that comes, it does take a lot of time. I agree with Mr. Hegde. Therefore, let us wait, and our courts are very robust.
Which is what the point of the opposition really is, that sufficient time really should have been given as far as the implementation of these laws are concerned, because you have to train and sensitize officials, SHOs and others, involved in the criminal justice system. Overall, an institutional preparedness is something that of course the government should have a thought of, because you have lakhs of personnel really who are part of this overall system. Mr. Hegde, your comments on that?
See, that's the question. When do you spend the time? You had to spend the time before these laws were passed, or before they were brought into force. It's one thing to pass it in a truncated parliament, but you are aware that parliament was truncated. Then what was the hurry to bring it into force on the 1st of July? You could have very well said that yes, the past parliament has passed it. We'll stay the implementation. Let this parliament, where everybody is there, let us discuss it and let's see if any amendments can make this law more palatable or more citizen friendly. No, this is a government that runs by diktat, and it likes to set arbitrary dates. From such and such a date, your money is useless. We have demonetized it. It's similar. It's a kind of similar exercise with regard to the criminal law. Your civil liberties are useless. They no longer exist. We are giving more powers to the police, and thereafter, whatever problems come, let the courts sort it out. The courts can't sort out problems with bad laws because they do not rewrite. They do not rewrite the laws. They can only interpret the laws, or they can stay it altogether and strike it down altogether.
Absolutely.
There is no question now of staying these laws, because if
Mr. Hegde, since we're completely running out of time, I have to get in your closing comments and closing comments of Mr. Desh Ratan Nigam. But I'll ask you, Mr. Hegde, once again, what are some of the changes that are further needed as far as these laws are concerned? What's a viable approach going forward?
Is to have a full-fledged parliament discussion and say, please come out, suggest amendments, and we are ready to take it on board. Let us make it a law which is workable and fair to everyone. Let us not be stuck in our egos.
All right. Mr. Desh Ratan Nigam, your final comments on what kind of changes are further needed and how can the view of the opposition be incorporated as far as these laws are concerned, and how can these concerns really be addressed?
Well, Sumita, huge amount of exercise has already gone so far as to train people. Seminars and everything has happened. The law was passed in January, and therefore one cannot say that exercise has not gone. Yes, it's a continuing exercise. Now, any change if the opposition wants, they can move an amendment bill. Nobody stops them on particular clauses, and discussion will take place in the parliament. But till now, the session has started. Probably opposition will take some time to, draft their own bills for amendment. You can move that particular amendment, have a discussion, and if required and both the parties agree, it will be put to vote, and those changes can be brought in. I think if the opposition has certain apprehensions, that is the beauty of our democracy. They have all the right to bring in those amendments, and they have a freedom to do so. But rhetoric outside the parliament and inside the parliament without bringing those amendment bills will certainly not serve any purpose. Opposition is free to bring their amendments to the particular act.
And this is really what Home Minister Amit Shah also stated today, that he's open for discussions and deliberations and whatever suggestions any member of the civil society may have, they can, of course, take it up with him. On that note, thank you very much, gentlemen, for sharing your views. Overall, it's a continued exercise, like Mr. Nigam was saying. However, the big question is really about implementation and rightful enforcement as far as these laws are concerned, because eventually it is going to be an effortless implementation that will really have a strong impact on the future of criminal justice system in the country.
If you like this video, then like, share and subscribe to ET Now.